Good evening. This is Stephen Leskin. I am a divorce attorney in Portland, Oregon, and this is my bi-monthly Oregon Divorce School webinar. I've been practicing divorce law for more than 30 years. I've been doing these webinars for the last couple of years. And what I do is take one particular topic and spend an hour just running through that topic. Tonight, we're going to discuss uh, trial and what a divorce trial is like. And we'll spend an hour talking about what I'm just randomly calling the three stages of trial: pre-trial, trial, and then post-trial. So that's tonight's topic. And we're going to spend an hour talking about just what the anatomy of a divorce trial. I don't like to take questions during the webinar, but I am available for phone calls or emails afterwards if a question comes up. I'm happy to take the time to talk to people about webinars or whatever question you may have about Oregon law or your case. And if you are registered for this webinar, you have my web address. But anyways, it's leskinlaw.com. And the phone number, if you want to jot it down, is 971-930-4716. Okay, so let's get into it. Trial. Um, I have been trying Oregon cases in the Oregon courts for about 30 years, and I've been doing divorce law since about 2000, so 20 years. And um, what I've the way I understand a trial now and the way I express it is that a trial is nothing more than the presentation of evidence. And evidence is shaped by what the law is and the rules of evidence. And the way evidence comes in is either through documents or through spoken testimony in the form of witnesses. And so lawyers spend an awful lot of time. I know I spend an awful lot of time trying to shape the evidence to support my client's case and to make sure that the correct evidence is coming into the record for the uh, judge to decide a case. Before I get too deep into it, I want to say that uh, divorce trials are always to the bench. There's no jury trial in a divorce case, at least in Oregon. And uh, I have tried to look up the reason why that is. And I have to admit that I wasn't successful, but I think it's because there's federal law um, that dictates child support and child support collection practices, and which is more or less unified child support throughout the country. And part of the deal in unifying child support and taking that particular issue out of a jury's hand is that uh, states agreed to give up jury trials. And I can't find the site for that. But I'm pretty sure that's the reason why there's not a jury that ever sits in judgment of a divorcing couple. The other thing I would say is that um, Oregon is a no-fault state, right? So it doesn't matter why a couple wants to get divorced or why one of the spouses wants to get divorced. Nobody cares. Nobody should care. It's your business. It's between you and your spouse and maybe you and your conscience. Uh, but once, uh, so all you have to do to get a divorce in a no-fault state is allege to the court that there's been a breakdown of the marriage and that it's irretrievably and irrevocably damaged beyond repair, and the court has to grant the divorce. It's not optional. The court has to grant it. If one person comes into court and says, "I deny that the marriage is broken and I think we can put it together," the court still has to grant the divorce. There's no keeping a couple together um, against one party's will, one of the spouse's will. So it's inevitable that if somebody comes into court alleges the magic words about that the damages the marriage is irretrievably broken and irreparable, then the court has to grant the divorce. I've often thought about what it would be like back in the day when there were faulted divorces and jury trials. And you have to come into court and say, my spouse cheated on me, and here's the evidence. And it would go before a jury, and jury may say, well, we don't think that's sufficient cause, or we don't think you actually proved that there was infidelity. And the couple would uh, be required to stay together. They wouldn't get the divorce. I mean, I've often thought about that. And then can you imagine the ride back to the house? You know, everybody's in the back seat, nobody's talking to each other, everybody's looking out the windows when you lose a divorce trial like that. So things have definitely progressed for the better in terms of divorce law. There's talk about making, recently there's been talk about making states have faulted divorces again. That's something for the states to decide. That's not federal law. There are some exceptions, but for the most part, all of the issues in the divorce court are state issues, not federal issues. Some of the federal issues pertain to certain types of retirement accounts that are protected by federal law, and those get divided pursuant to federal law, um, or at least the mechanics of it are divided pursuant to federal law, even though the division of the property is still state law. So, the long and short of it is, a divorce trial is always going to be state law tried to a judge, not a jury. Okay, so I said we're going to break this down to three parts, and the first part is going to be pretrial. The second part will be the trial itself, and then the third part will be post-trial. So let's start with preparation, the first part. Um, I've talked about this in other webinars, the process called discovery. So uh, a, a, a trial begins with filing a petition, and then there's a response to the petition, and then parties exchange information, and that's discovery. And through discovery, the parties gather evidence from the other side about, in a divorce trial, uh, about assets, the liabilities, the income, and the property, generally the property of the marriage. And so that's what the discovery process is. It's the creating an inventory of all of those things in the marriage. And so part of that is just gathering evidence and thinking about how that's going to come into evidence and how that supports a party's case. So pretrial is the collection of evidence to present at trial. And that evidence, I'm going to say this again and again, that evidence can be in two forms. It could be spoken testimony or it could be documents. And then there are rules of evidence, the rules of evidence that govern how each of those things come in. The most popular rule of evidence is hearsay, which is an out-of-court statement offered to prove the truth of the matter therein, which means that you cannot offer evidence that uh, somebody else told you. So all evidence has to be knowable to you directly, to the witness directly. So um, when a witness testifies, they're only testifying to what's within their personal knowledge. There's some exceptions to that, of course, but the important thing is that the witness talk about what they know factually to be true through their own senses. So, and then documents could be things like, bank accounts or insurance records or retirement account records. Uh, and then those come in a specific way too, that they have to be authenticated so that the court and the parties know that the thing is what it purports to be. And so part of presenting that evidence is making sure that the person who's offering that record knows that it is what it is and that it is in one of the hearsay exceptions, right? Like a bank statement is hearsay. It's an out-of-court statement that there's $1,000 in a bank account, right? Nobody, you need to test the bank statement is that statement showing how much is in the bank account. So it's necessarily hearsay, but it might come in under the business records exception to the hearsay rule. And whoever um, is testifying has to be able to testify this is a business record made in the course and scope of business. So, um, and that they know it's the true and complete copy of what it purports to be. Um, so Pre-trial, the attorneys are gathering that evidence and maybe speaking to potential witnesses and preparing the documents, what the evidence, which will be called exhibits for trial. And so, usually, discovery is probably the most time-consuming and therefore the most expensive part of a divorce trial, and it's also one of the most important parts, so that you know what the other side has, they know what you have, and that hopefully you're minimizing surprises, and you both have the same set of facts to work on at trial. So that's pre-trial. Um, uh, Once you get into like trial, then there's specific trial prep. Trial prep includes uh, preparing witnesses to testify. It includes preparing your exhibits. It includes preparing certain documentation for the court. I'm going to talk about that now. And I should have said this at the outside. My comments are geared towards divorcing couples, but this everything I'm saying is also true for a couple that's going through a custody battle where there's a child but no marriage. And so everything I'm saying now will also pertain to a custody case. It will also pertain more generally to other types of lawsuits, whether it's criminal or, car accident case. But There's a focus on divorce. Uh, but the comments are going to be exactly applicable to a custody case as well. Um, so the documents that need to be prepared are a hearing memo for the court, and the hearing memo tells the court these are the issues that we see in the case, and those will be maybe if there's kids, it will deal with the child support and the custody and the parenting time. If there's assets, it will discuss the assets. It will discuss um, the debt. It will discuss spousal support if that's appropriate. And those are the general issues. If there's quirks in the case, a good trial memo will alert the court to the quirks so the court doesn't get surprised. Um, it will try to frame the issues in a way that's favorable to the husband or the wife or the petitioner or the respondent. Uh, and the petitioner, just to say it, is the person who actually files the divorce. That person is called the petitioner. They file first, and the person who responds is called the respondent. Um, and so both parties, both petitioner and respondent, prepare and submit a hearing memo. They are required to submit an exhibits list listing out all of their exhibits. Typically that's done in court at the trial. More and more times the attorneys will exchange those beforehand, particularly if a lot of the documents are going to be, similar or the same documents. Uh, the parties in most counties in Oregon are required to submit what's called an assets and liability statement. And an assets and liability statement is a spreadsheet that lists all of the assets in one column and their values, and all the liabilities in another column, and then shows um, through the wonders of mathematics what it would take to get each party to the same number, right? So a house is worth has suppose the only asset in the house in the marriage is the house and there's $300,000 in equity, right? The assets and liabilities would show an attribution of $150,000 to each spouse. But obviously, it gets more complicated if there's debt and other assets. And then it gets really complicated if there's financial instruments that need to be valued, retirement accounts that need pension, particularly pension accounts that need to be retired. Then it gets very, very complicated. But it's simple, there's a house, two cars, maybe $100,000 in investment accounts and a retirement account. That is pretty straightforward to do the math to figure that out. The math is um, the formula is pretty simple. Assets minus liabilities divided by two, and then whatever number it takes to get um, both parties to the same uh, number is how it's done. So that's an assets and liability statement. So you got the hearing memo, asset and liability statements, an exhibit list, sometimes a witness list, and all of those take time to prepare. and getting the exhibits together takes time to prepare. But these are all things that are done pre-trial. The other big thing is preparing witnesses to testify. When I prepare my clients for trial, I'm going through the statute, and we've done this multiple times before we get to trial, so nothing is new. But we will talk multiple times about um, uh, the statutory requirements that have to be proved, like particularly for custody. We'll go through what the law is on custody, and we're going to talk about and like examples of each factor to support a determination of custody. So, witness prep, exhibit preparation, hearing memo, and the other ancillary documents are all things that have to happen pre-trial. And um, Usually, there's going to be an opening statement, so the attorney has to give some thought to what their opening is or what their theme of the case is. Um, I'm working on a case right now. It's just fresh in my mind, so that um, I'm thinking this example because it's fresh in my mind, where there's two, to my way of thinking, there's two very, very distinct experiences that the child will have in a custody dispute. My client is had a stable job for years and years and years. Has been a long relationship for years and years and years, and the mother has a drug history and a chaotic life and is living in sober living and bouncing around between houses. What's in the best interest of that child? Clearly, the first situation. But so, my job as attorney is to draw out those dichotomies, right? And so the theme of my case is like, you got two very different experiences for the court to decide from. And so I'm shaping my evidence. I'm putting in evidence to support um, my client's position and evidence to undermine the other parent's position. So, uh, and then my closing at the end is going to come back to that theme that the child will have two very different experiences depending on what the court decides. So that's all done before the judge sits down and the parties sit down. And then uh, once we get into the actual trial, um, um, the judge will uh, put the case on the record, meaning that everything that says after that point is recorded. And the reason it's recorded is if the judge makes a mistake or the parties feel that the judge has made a mistake, that the judge's decision and the evidence it's based upon can go up to the Court of Appeals for review, which we'll cover just a little bit in the post-trial section of this webinar. So the record goes on, which means it's being recorded, and then the judge will introduce the parties and make it's called putting your parents on the record. I'm Stephen Laskin, and I represent the petitioner here. And then the judge will ask if there's any pre-trial matters. Usually, maybe somebody has something that they want to alert the court to. Maybe somebody has a request for the judge. If there's specific statutory requirements that have to be made before trial. For example, if somebody wants very specific findings of facts or findings of facts on a particular matter, you have to alert the court to that before the trial begins, and you should. Um, that's what comes to mind most quickly. But there are times when maybe there's going to be a quirk in the law and you want to ruling on something um, before trial begins. So you can ask the court to make a preliminary ruling just on the law. And uh, Once the preliminary matters are dealt with, if any, the court will turn to the petitioner, since the petitioner filed the petition, and say, well, would you care to proceed with your opening statement? And depending on the judge and the attorneys, um, nobody waives opening statement, but if you know that the judge has read your memo, may not be necessary to go into the same depth that you might otherwise not, or you might just want to highlight, um, things that you think are going to be important for the judge. You're not giving evidence. It's just kind of like you're the cliche is it's just your roadmap of the case that you're giving the judge um, as to like what you expect your case to look like. And then once the attorney's done pontificating, the other attorney gets a chance to offer their opening statement as well. And then the judge will say to the petitioner, you're up. And then the petitioner's first witness goes on, and is called to the witness stand and is sworn in, and then they start testifying. Um, almost all testimony is factual, right? You're like I opened with, a witness testifies to facts that they know through their own experience. And all of the questions that are going to be asked are going to call for factual answers. And um, if you don't know the answer, it's okay to say, I don't know, as long as it's truthful. It's okay to say, I don't understand the question. It's okay to say, can you repeat the question? I didn't hear you. It's okay to say, I don't understand the question. Sometimes attorneys ask questions that make no sense. And um, it's okay for the witness to say, can you repeat that? Or I don't understand the question. I tell people if it's like a question of um, like judgment, like how much do you think was in the account? You can say, I don't know for sure, but my best memory is, X number of dollars, something along those lines. So long as you're labeling it that it's a memory and not a fact, it's okay. Or sometimes I can't particularly think of a good example. Like, oh, well, for example, like, how much time, how many overnights did you have within the last year? I don't know, but my best estimate would be, the child spent, 100 nights with me. Um, so as long as you're labeling it that it's not a fact, I know it's a fact because I kept track of it. Like I have a calendar, and I can verify that the child spent 100 nights with me. Fact. But I think my the child was with me 2 nights a week. I would say that it was 100 nights. You're labeling that as an estimate, and that's perfectly okay. Um, the other side has the opportunity to object to a question when they anticipate that the question is going to contain hearsay or other objectionable material. Uh, um, and the judge will make a decision about an immediate decision about whether or not to sustain the objection, meaning that the testimony doesn't come in, or to override it, which means that the attorney can go ahead with the questioning. Uh, it takes years. It took me years to get good at the rules of evidence. And I sometimes still, to this day, look stuff up before going to trial. I want to know how to respond to what I anticipate will be objections. And I will have those things worked out before I set foot in the courtroom. After the witness is done testifying, they get cross-examined by the other side. And people get into trouble in cross-exam when they're guessing or when they're giving answers that they don't know about or giving answers that aren't factual or complete. Um, Another case that I just completed involved a person who had a drug addiction and did not disclose everything about their diagnosis to the court. And so my cross-examination was, um, didn't you go to jail for theft? And it wasn't theft. It was um, that doesn't matter. It was just like they were leaving things out, and I got to cross-examine on those issues, and it made them look not good. It made them look like they weren't telling the truth and they were concealing things. It was whether or not there was a specific drug abuse uh, um, diagnosis. So um, cross-exam will get at those things. And um, I'll give like one of my favorite cross exams that I did was on the value of crops back in the day when I was doing other types of trial work, and an expert had testified that they had spent 30 or 35 hours calculating the value of damaged crops, and that he'd done it within 2 weeks of trial, and that amount had corresponded to the the petition that was, or the complaint that was filed against my client. And it was the exact same amount, and that amount had been filed with the court. a year prior. And as soon as I said, "How do isn't it true that that this amount is in the petition and the petition is dated 1 year prior, that you are making shit up?" And it sound like that. But that was the gist of it. That all these hours that he spent, which just wasn't true. It wasn't believable after that. So um, that's what a good cross-examination does. Um, After the petitioner's put on his or her evidence, then rests, then the respondent gets a chance to go on and put on his or her evidence. Same thing that they put on their evidence, they're subject to cross-examination. And then once that's done, the petitioner has a chance to rebut. And the chance to rebut only pertains to the evidence that was already put on. You can't enter a new matter in a rebuttal. Only the petitioner gets to rebut evidence. It gets put on a rebuttal case. The respondent does not. And sometimes the rebuttal is the most important part of the case. Uh, so um, that's the three sections of a trial. After the rebuttal is done, the parties put on closing statements, and then sometimes, not all the time, but sometimes the divorce court will issue an opinion then and there. More often than not, it will be an opinion letter that the judge issues a couple of weeks after the trial. And then, um, so now we're into post-trial matters after the opinion comes out. The court will designate one of the parties to draft the general judgment of dissolution or the general judgment of custody. And after it's drafted, it's circulated to the other spouse to review and make sure that it's in conformance with the court's decision. If it is, then both parties sign it. If it's not, there's a mechanism for going back before the judge, and both sides argue about whether or not the proposed judgment corresponds to the judge's rulings and doesn't contain anything more or anything less, and that the language reflects what the judge intended it to reflect. And um, uh, sometimes it doesn't happen too often, but sometimes there's just you can't fathom what the judge or have a clean interpretation of what the judge wanted, and then the parties will just bring it back before the judge for clarification. It's pretty easy to write a judgment now. All the hearings are recorded, so all you're doing is requesting a hearing tape, and then you can draft it if your notes aren't complete or your memory is not complete. And then after it's drafted, everybody agrees to it. It's signed, um, or at least it may not be signed by the parties, but it's signed by the judge. Uh, then it gets filed with the court's registry, and then it's official. Once it gets signed by the judge and then entered into the court record, it becomes the official judgment of the case. Um, and now we are into post-trial matters. And so the two post-matter trials that I want to talk about, three actually. One is modification of the judgment, two is an appeal of the judgment, and three is enforcement of judgment. And I've covered this really, really in depth in other webinars, but I will just give an overview of each of these topics now. So suppose spousal support is awarded, right? And husband makes $10,000 a month, and the judge and wife makes $2,000 a month. So there's $1,000 a month spousal support in favor of wife. And then husband retires and his income is cut in half. He can go back to the court and say, there's been a change of circumstances that wasn't anticipated at the time of the judgment. And I would like to modify the amount downward of the amount of spousal support that I'm paying. And that's a modification. Modifications can happen with custody, right? The court awards one custody, sole custody to one parent or the other, and the other times change. Maybe one of the parties, maybe the parent with custody of the children goes through hard times. Maybe their health goes bad, or who knows. But there's some factual basis to say that it's no longer in the best interest of the child that mom should have custody. And so you can go back to court and modify the judgment. Um, in a divorce case, you cannot modify a property settlement. Once it can be appealed, but once a property settlement is set, it's set. There's no going back and modifying, for example, who's going to get what equity out of the sale of the house. Once the judge decides that, unless it's appealed, um, that's the way it's going to be, unless it's appealed and reversed. Uh, how to the second post-trial matter is enforcement. So let's say that same couple, wife is getting $1,000 a month, husband doesn't pay. What are wife's options? Wife has a judgment against the spouse, and she can exercise her enforcement rights under Oregon law, which includes the right to garnish an account, the right to garnish a paycheck, the right to seize an asset, the right to call the non-paying spouse in for what's called a judgment debtor exam, where you can say you are required to bring all of your bank accounts, all of your certificates of title, all of your investment accounts, and the person conducting the judgment debtor exam, the judgment creditor, is entitled to look at all that and figure out, okay, here's the money. I'm gonna garnish um, the investment accounts of the non-paying spouse. So there are those types of um, remedies, enforcement mechanisms available for to collect monetary amounts owing and not being paid to one of the spouses. Um, it becomes more tricky with how do you enforce like parenting time or uh, the spouse's uh, the child is being subject to disparaging comments from one of the spouses about the other spouse. How do you enforce that? So you can go to court to enforce a judgment. There's an expedited procedure in Oregon law, particularly to enforce parenting time. You can call the court and ask for how to do it, or go online and find the papers to file that. You don't need a lawyer particularly to do that, and you'll bring in your evidence, and the other side bringing their evidence of willful uh, disobedience with the judgment, and um, the judge will decide. The problem becomes enforcement, right? So the judge, the first time will say, "Don't do it again." And if you come back again, then there'll be more severe penalties. The judge has a wide range of options to impose sanctions or take away parenting time or impose monetary penalties. Um, then the third option, and really the one that is most harsh, is if a judgment is or if a court order is violated, then you have the power of contempt. You can go to court and say, I want $500 up to a $500 a day fine for each day that um, the judgment is not honored. And then there's all kinds of other sanctions that go along with that, payment of attorney fees. Um, it's possible everybody threatens, jail time, but you have to get permission from the DA to do that first. And it's a really cumbersome process. It's not used that often. It's threatened. Really, I've never seen it actually happen in a civil matter where somebody goes to jail for non-payment or non-performance of a judgment. But contempt is the general way that um, judgments are enforced. And unlike in a regular trial where the burden of proof, meaning how certain you have to be of the evidence, in a civil case is just a preponderance, just enough to get there. Uh, in a contempt case, it's beyond a reasonable doubt. It's the criminal statute, right? And actually, it may actually be clear and convincing now that I think about it, and I don't recall which offhand, but the clear and convincing is even a higher standard than beyond a reasonable doubt. So contempt is pretty hard to prove by either standard. Um, and so that's modifying judgment, enforcing a judgment, and then appealing a judgment. And so you've had your trial and um, you didn't get the ruling you want. You thought that it was obvious and the judge just didn't get it and made a mistake, or the judge applied the wrong standard. Um, you can file an appeal with the Oregon Appeals Court. You have 30 days after the judgment is entered to file it. And I will say from experience that filing an appeals case is complicated. It's really a narrow area of practice. There are only so many attorneys in the Portland metro area in the state who file appeals. They are difficult to do and hence very expensive. And your chances of prevailing are, who knows? The Court of Appeals no longer issues. Uh, I want to explain how the getting the chance that you're going to get a case heard is pretty low. A lot of times they're just affirmed or affirmed without decision or comment. And so it's really a long road to get a case reversed and then remanded to the court. The burdens are very, very high in appealing what you think is a wrongful decision. So you have to get it right in court. You have to make sure that the court gets it right. You have to the attorney has to know the law sufficiently to correct a judge if you think that the judge is getting a standard wrong or is going to apply the wrong law. You have to make that correction on the record in real time. Um, and so appeal is it's you got to have money and you got to have be pretty certain that you're on the right side of that. So that's all about divorce trials. Um, uh, I I kind of like being in court these days. I've done it a long time. I have a feel for the courtroom, but even for somebody who's done it a lot, it is always stressful. Like, I know it's going to happen, and it's stressful for me. And I think that's true of most of my colleagues. That going to trial is always hard to get. It's always time consuming and pressure filled to get there. And then once you get there, it's just very stressful. The stress leaves once I start talking, uh, but getting the result is stressful, and not knowing which way the court is going to go is stressful. So. Uh, Parties have the option to mediate and to come to a settlement. Most parties do. In fact, very few cases actually go to trial. Probably 80% of my cases, I think the general number, not just my cases, is about 80% settle before they get to court. But that is the process, and I hope you found this helpful. If you have questions, please feel free to give me a call. I'd be happy to walk through with you or answer specific questions. And again, my website is leskinlaw.com. I am Stephen Leskin, and I'll leave with my phone number. It's 971 Thank you for joining me tonight. And I'll be on again in 2 weeks, and I'll hope to see you then. Thanks.